Good evening, ladies and gentlemen. Suzanne Dibble, data protection law expert, coming to you raw and uncut. And today I want to talk to you about data processes and in particular the liability of data processes. There seems to be a lot of concern, understandably, about the liability of processes under GDPR. And the reason why is that I've read a lot of articles that say that what is new is that processors have liability under GDPR. And I think that what people therefore assume is that the processor is liable for the actions or non-actions, so either compliance or non-compliance of the controller, the data controller, and that's not the case. So I'm going to be saying a little bit more about that. Now, if you don't know what a processor is and what a data controller is, then go and watch the 2-hour training that I did. The link to that's in the pinned post of this Facebook group. But just a very quick reminder, the data controller, as the name suggests, is the person who controls the information. And the processor, as the name suggests, is the person that processes the information. So I've had a lot of questions in the group from virtual assistants who are concerned because they are the processors. They have clients that ask them to do various things with that data, and they are processing that data. So yes, it's absolutely true that GDPR gives processors additional liability, and I'll come on to talk about what that is. But what is not true is that the processor is vicariously liable for the non-compliance of the controller. So I'm going to talk you through what the actual position is and how you can protect yourself as a processor, whether you're a virtual assistant or any other type of processor. Okay, so what does GDPR say about processors? Well, Article 28, first of all, aside from any issues of liability, Article 28 puts an obligation on a controller, a data controller, to only use processors that provide sufficient guarantees to implement appropriate technical and organisational measures in such a manner that processing will meet the requirements of this regulation, i.e. GDPR, and ensure the protection of the rights of the data subject. So before you even start to think about your own liability, think about your future jobs as a processor, because as people get more knowledgeable about what GDPR says, and as there are more cases where the ICO have investigated and fined people for not being compliant, it will become more well known that there is an obligation now on data controllers to only use processors who are in effect compliant with GDPR. So you need to get your own house in order first and be giving your own clients confidence that that's what you are doing. That's not about your liability. That's about just continuing to get work. Okay, the second point is that you have to have a contract. Now, under existing law, you're supposed to have a contract between the data controller and the data processor. But GDPR now specifies a number of things that are to be included in that processor contract. Now, I've included a processor contract in my GDPR pack, and in the schedule it says it's going to be released in, I think, week 6 or something like that. But due to a number of requests in the group, and I agree it's an important document, one that potentially might need to be negotiated where you've got existing relationships, that's going to be moved up the schedule and will be released next week. So to get your compliant processor agreement, then go and check out my GDPR pack. It's an introductory price of £97, and the link to get it is in the pinned post. Okay, but there's a number of things that the contract has to set out, including that the processor only processes the personal data on documented instructions from the controller, including with regard to transfers of personal data to any third party. It ensures that persons authorised to process the personal data have committed themselves to confidentiality. So, I mean, confidentiality would very much be in a processor agreement already. That a processor takes all measures required pursuant to Article 32, which is all about the security of processing. It respects the conditions referred to in paragraph 2 and 4 for engaging another processor, and that is all about subcontracting work as a processor, and I'll come on to talk about that in a bit. Taking into account the nature of the processing, assists the controller by appropriate technical and organisational measures. The processor assists the controller in ensuring compliance with obligations pursuant to Article 32 to 36, which are all about security, notification of a personal breach, of a data breach to the supervisory authority, communication of a personal data breach to the data subject, data protection impact assessments, etc. Now, I don't expect you to remember all this, so I'm going to direct you to some resources, but I just want to flag the types of things that need to be in that agreement. Now, of course, the easy route is just to get my agreement and it's all covered off. But let's talk about the sub-processing point, because I know that some of the virtual assistants, this is, I'm specifically referring to virtual assistants in this video because there's been a lot of questions in the group, but what I'm saying applies equally to other processors. So where you do, as a processor, engage another processor, so a sub-processor, if you like, then first of all, that has to be specifically approved by the controller, as you might expect. But you have to have a similar contract with that sub-processor, in particular the fact that they provide sufficient guarantees to implement appropriate technical and organisational measures that will meet the requirements of the regulation. So if you're a virtual assistant and you use associates, for example, then you've got to be just as thorough in checking those associates out to make sure that they are GDPR compliant before you pass on that work to them, in addition to getting the consent of the controller. I'm not going to read any more detail of the Act tab, but I do want to refer you to some great resources, which I will do now. In fact, let me just talk about the liability, because this is a big piece of it, and then I'll refer you to the resources. Let me just scroll down here and find the right place. Okay, so the document that I'm going to refer you to is a guidance note from the ICO, and I'll put the link to it in the comments. And the key section on this is the bit that is called "What responsibilities and liabilities do processors have in their own right?" And there's the contractual obligations that I've just talked about, but there's also direct responsibilities under the Act. For example, not to use a sub-processor without written prior authorisation of the data controller. Just talked about that. Do note that's written authorisation, so oral authorisation won't suffice. The processor has direct responsibilities to cooperate with supervisory authorities such as the ICO. The processor has obligations to ensure security of processing, to keep records of processing activities, to notify any personal data breaches to the data controller, to employ a data protection officer if you need to, and I've done a separate video on whether you need to appoint a data protection officer, and to appoint a representative within the EU if needed. That's if you're outside of the EU, then you need to appoint a representative within the EU, and I'll do a little video on that at some point in the future. And if you fail as a processor to meet any of those obligations, or, this is the key part, if you act outside the instructions of the controller, then you as a processor may be liable to pay damages in legal proceedings or be subject to fines or other penalties or corrective measures. And if you use a sub-processor, then you will, as the original processor, remain directly liable to the controller for the performance of the sub-processor's obligations. So that's another key point for anybody who uses associates or sub-processors. You've got to do your due diligence on that sub-processor and make sure that they are GDPR compliant, make sure that they're great and they're going to do a great job, and also look at in that agreement, look at some back-to-back indemnities in the event that you are liable to the controller. To cover off that risk. So what else do I need to tell you about this? Okay, this note just goes into what I've just said in a bit more detail. So if this does apply to you, then go and have a read of that. Okay, a processor can also be held liable under Article 82 to pay compensation for the damage caused by processing where it's failed to comply with GDPR provisions specifically relating to processors, which are the ones that I've just gone through, or where it has acted without the lawful instructions of the controller or against those instructions. So I think that's where, as VAs and other types of processors, you've got to be really careful to get very specific, ideally written instructions from the controller as to the processing that they want you to do. Because if you act against those instructions, or even if you do anything where you haven't had instructions and you're processing that data, then you could, in theory, be liable to pay compensation for any damage caused by that processing. So do make sure that you're going to have to be much more careful to document workflows and instructions as to what the controller actually wants you to do with that personal data. The note from the ICO says, we will provide more guidance on investigative and corrective powers, penalties and damages in due course. So let's watch this space. But what it does say in the note is all this provides a very strong reason for you, and in this instance they're talking about a controller actually, so this provides a very strong reason for the controller to make sure that your processor is aware of the consequences and penalties which it may be subject to if it fails to comply with GDPR. The GDPR has real teeth in terms of enforcement, which could have serious operational and financial implications for both controllers and processors. Okay. Yeah, there's a bit more about sub-processors in there that you can have a look. And then it's got a really handy checklist for controllers and processors at the back of that guidance note. So even if you just look at that checklist at the back, that is a good place to start. The one right at the back is the processor's responsibilities and liabilities checklist, which gives you a little checklist of the things that I've just talked you through. But the main point that I want you to take away is that you are not. So I know there's been a lot of talk in the group from virtual assistants who are thinking that if their data controller, so their client, hasn't obtained proper opt-ins for marketing email, sending marketing emails, things like that, that if you continue to market to them, then you as a processor would be liable. That's not the case. So I've read out the specific and more general, but the exact ways in which a processor could be liable. So you obviously need to have mind to those, but don't think that it widens the scope of your liability to being, as I say, vicariously liable for the actions or failure to act of your data controller. Okay, so I hope that puts your mind at rest to a certain extent. I think the things you've got to be very careful about, as I've said, just to summarise, are making sure that you're compliant, number one, because there isn't an obligation on the controller now to only use processors that provide sufficient guarantees to implement appropriate technical and organisational measures in such a manner that processing will meet requirements of the regulation, so i.e. you're compliant with GDPR. So that's step one, get your own house in order. Step two is the contract. So do go and get the processor contract from my GDPR pack, which is coming out next week, and make sure that you put that in place with every data controller that you're working with. Think about your workflow. Make sure that you're getting written instructions for every piece of processing of personal data that you're doing, because your failure to not act in accordance with those instructions, whether that's deviating from instructions or acting without instructions, could result in liability for you as a processor. The fourth thing to think about is sub-processors. So to make sure that you thoroughly vet any sub-processors or associates that you're using and make sure that they are GDPR compliant. Also make sure that you've got exactly the right form of agreement in place with those subcontractors. And then the final thing that I just want to say is if you haven't already, it's probably worth speaking to your broker about your insurance and checking whether you need to increase the scope of that insurance for GDPR. And if they say you do, then obviously it'd be a good idea to up that insurance to cover that. But I think that, I think it's obviously daunting if you're a sole trader VA and you don't have a lot of resources to back you up. It's I can imagine it's very daunting to have this regulation hanging over you. And I can quite understand the people who post in the group to say I'm thinking of just cutting out doing the data processing altogether. I think it'd be really interesting to see what cases come out of this, but I think that these regulations and the ICO are not looking to catch people like you who are helping a couple of clients or however many, 20 clients, however many, with their email lists and inputting data. These rules are really for the larger scale processors, and as I've said in certainly in my video last night and previously, unless you're doing something that is significantly out of kilter with what the regulations are all about, and you've got a minor non-compliance, then chances are that the ICO would have a word with you, explain where you're not compliant and give you a period of time to get compliant. So I think actually that this does actually represent an opportunity for processors who are familiar with GDPR, who can say that you are compliant when you're pitching to new clients or talking to existing clients about GDPR as they become more knowledgeable about what's involved with it. I think it's an opportunity. So I think if you follow the simple steps of being GDPR compliant yourself, and then you're mindful of the other issues that I've raised, you will be absolutely fine. So I hope that helps. That was a general processes video with a virtual assistant slant. I know I've had lots of questions from virtual assistants in the group. If there's anything that I've not covered there that you are interested in, then let me know. But I think from looking through all of your questions and comments, that it's the processor liability angle that seems to be concerning you most. So I hope that I've set your mind at rest to some extent on that. Okay, I'll leave it there. Thanks so much for watching as always. If you haven't yet watched the 2-hour training, then go and check out that. You can get the link to that in the pinned post. If you haven't yet got your free checklist, you can go and get that, link for that in the pinned post. And if you haven't yet bought your GDPR pack, then it's still at the introductory price of £97. That's in the pinned post too, so do go and get that as well. But yeah, thanks for your continued support. And I was trying to, I'm not actually sure I was going to say what the video is tomorrow, but I'm not actually sure. I know I'm going to be doing one on photography soon, so I'm looking forward to that one. There's lots of photographers in the group, I've noticed. And the group's just going mental. I've got a backlog of like 400 people, 450 people to approve into the group. And we do go through each one of them because we really have to try hard to make sure we don't let the spammers in. So lots of interest still, which is absolutely awesome. Have a wonderful rest of your weekend, and I'll speak to you soon.